Good. Thank you. Welcome to the ADRC Commission Quarterly Meeting. This is the fourth one of this year. And so I'll welcome all the commissioners, but in addition, those of you that are streaming and watching this through the YouTube, then welcome to the meeting. And so what we're going to do is there's an agenda that's been submitted to all the commissioners. I assume all the commissioners have received a copy of it. And so I'm going to turn to the agenda itself. And so are there any corrections to the July 18th, 2023 minute meetings? I know we corrected that a little bit earlier. We had 2022, my fault. Are there any corrections to those minutes? Okay, if there are no corrections to those minutes, do I then have an approval as approved? Is there a approval of the minutes as being presented?
I move to approve the minutes as presented.
Second.
Okay, there's been a motion and a second, although I'm going to have you raise your right hand so we can see. Sometimes it's hard to hear. All those in favor, raise your hand, please. Okay, all right, we have a majority. The minutes have been approved. Thank you, Dana, for making that correction and getting it. And so we're going to, as soon as Justice here he is. Hi, Justice Tarwater.
Hello, everyone. I just noticed the agenda says 10:30, but the Zoom link said 10. So am I 30 minutes late? I hope
finished.
No.
Oh, Tarpley, I wouldn't believe anything that you said anyway.
Hi, Justice Tarwater. You were absolutely, you could not have had it timed more perfectly. That is the next thing on the agenda was the introduction of Justice Tarwater. And I understand you already know several of the commissioners here, but I thought what we would do is I would go down the list of commissioners and let them very briefly introduce themselves, because this is your first commission meeting and this is the first time actually meeting the commissioners on the ADRC. I'm correct, is that right?
It is indeed. And thanks for that, Stephen. I appreciate it. I do know many of the members. In fact, I'm glad that during my background check that they didn't call John Tarpley, that did not call John Tarpley. So,
I did. So
there's also some construction going on behind me. So if that becomes a nuisance, let me know and I'll mute my.
Yeah, we can't hear anything right now, but I thought I'd let the commissioners and then turn it over to you and let's hear more about you. But you're going to become the liaison to the commission. And so Cindy Attengolf, let's start with you.
Thank you. Good morning, Justice, and thank you for joining us. Hey, I am a dual listed family and Rule 31 mediator, civil mediator. I'm also the CEO and general counsel for Memphis Area Legal Services. And for us, mediation is wonderful because we view it as a tool for access to justice. So it's very nice to meet you. And I look forward to working with you. And you're going to love this group, despite John.
And so,
well, I'm glad. And you all, I really appreciate the decorum and the respect, but y'all need to call me Dwight if you can, unless I've got the robe on or something. I'm not that far. If you want to persist, go ahead, but I'm giving you a blank check. Okay. So I'm not 6 weeks ago, I was in your chair. so I'm not that far removed, but nice to meet you, Cindy.
Yeah. And Cindy is from Memphis. And so she's from the Memphis area. And so Sarah Figo.
Yeah. So as a non-attorney, I'm happy to call you Dwight. So nice to meet you.
Nice to meet you, Sarah.
I'm based in Nashville. I run the Nashville Conflict Resolution Center, which is one of the 7 community mediation centers in the state. We've been working really hard to bring the mediation centers together to work as a coalition to help translate the impact of what community mediation is doing to the rest of the commission, to the AOC, and therefore to the rest of the state, and expand services.
Yeah, thank you, Sarah. Thank you. And so I think you know Mark Harwell.
I do know Mark Harwell.
Great to see you, Dwight. You know me, I'm in Chattanooga, Tennessee with the Harwell Hearst Law Firm. And as far as alternative dispute, I'm happy to say that Hamilton County is trying to catch up with the other major cities in the state. And just last month, we started an ADR program in our General Sessions Court to try to deal with our landlord-tenant problem in Hamilton County. And so we're just getting that off the ground. I've been working closely with Judge McVeigh, and we've had some great input from Jackie Kittrell and Dawn Forche. So I'm hopeful that in 6 months, I'll be able to report to everyone some huge success in that regard.
Very good.
Thanks,
Thank you,
Mark. Good to see you.
Yep.
Yeah. Charles Hill goes by Chuck. Chuck, introduce yourself to the justice.
Good morning, Justice Tarwater. I am another non-attorney mediator. I've been mediating since 2009, both family and civil mediations. And I also hold an appointment as an ombudsman with the Department of Defense, mediating issues between employers and service members who have been deployed at either the reserves or the National Guard. So it's a pleasure to meet you, sir, and I look forward to working with you.
Pleasure to meet
Thank
you,
you.
Chuck. Where are you from? I think I might have
I'm in
missed that.
Nashville.
You're in Nashville. Okay.
Rick Ladd.
Hello, Justice Tarwater. My name is Rick Ladd, and I'm a civil litigator who happens to mediate at times. So my role on this commission is basically just to listen and learn. And every now and then I get to provide some input that is ignored by all. Nice to meet you.
Well, he's not being straight up with you.
He's not at all.
He's provided great insight and great service, and he, like I, will be rolling off of the commission at the end of this year. And so, thank you, Rick.
Sure.
And so, Betsy.
Good morning, Dwight.
Hi, Betsy. How
As
are
you know,
you?
I'm in Knoxville, and I do not nearly have the credentials that the rest of these people on the commission do. I practice family law and practice, I guess my biggest claim to fame is that I share office space with Celeste Herbert, who is responsible for me being on this commission, and I thank her for that. I do exclusively family law mediation here in Knoxville, and I've been doing it for about 23 years, and that's about all you need to know. Welcome to the commission and your role with us. I look forward to it.
Thanks, Betsy. Good to see you. Say hey to Celeste for me.
I will.
She and I used to practice together, and we've
I
been
do know
friends
that.
for like
There's another
40
connection.
years. I mean, that's a lot.
It is a long
This is good. Yeah, this is
We're
good
not
they're
that
on
old.
these
I don't know how this happened.
And Lori Reed. Lori's had a little voice problem, but Lori, let's turn it over to you.
Good morning, Justice. I'm slowly getting my voice back, and I hated to miss our workshop this week. I had to watch it on Zoom at home instead of participate, but it was a really good one. I'm a 30-year practicing family law attorney in Franklin. I've been listed mediator for quite some time, and I love what I do, and I've really enjoyed being on the commission and met some new people, and we actually have fun while we do what we do. I'm Ole Miss grad, hotty toddy, and just hope everybody has another good year.
Thank
So,
you,
Lori, I think you said you were from Franklin. Is that what I heard?
Yes, yes, sir.
Franklin.
Cheatham,
Yeah,
Palermo, and Garrett is my firm, and I'm that's what I do all day, every day.
Thank you, Lori. Thank you. Marcus is not with us. Is that correct?
That's correct.
I don't see Marcus. Okay. Linda Seeley.
Hello, Justice Water. Thank you so much for joining us. We're so glad to have you on board. My name is Linda Warren Seeley. I work at the law firm of Butler Snow. I am their pro bono counsel. In the past, however, I served as the director of the section of dispute resolution for the American Bar Association. I am a Rule 31 listed family mediator, and I am the chairman of the board of the Mid-South Community Justice and Mediation Center, which is a small community mediation center in Memphis. Thanks so much for joining us, and we look forward to working with you.
So I know a lot of your sidekicks there at Butler Snow, and I'm assuming you're in the Memphis office. Is that right?
Yes, I am in the Memphis office and have many sidekicks all over the state.
Uh-huh. Interesting. And so, John Tarpley, I think you know the justice, don't you? I think he's already indicated maybe too much.
Dwight, how in the world are you? It's great to have you here. Congratulations. I'm very proud of you. I was trying to think back when we met and I could not remember, but I think our friendship is now about to hit 5 decades, but I'm not sure on that. So I am dating each of us a bit. I'm a lawyer, as you know, at Lewis Thomason in Nashville. I call myself a simple country lawyer, and I'm also a mediator. And you're going to love hanging out with these people. This is a fun group, and we accomplish a lot. They're your kind of group.
Absolutely. Gail Ashworth.
Yes, thank you. Hello, Dwight. It's good to
Hi,
see you
Gail.
again.
How are you?
I'm doing well. I just came from a TIPS conference where we had a new leadership academy, and Dwight has spoken to our leadership academy many times in the past. I'm sorry you could not be in Nassau with us. I'm actually not a commissioner. I liaison to the commission from the Access to Justice Commission, where I was chair several years ago. Reason being, it is helpful to the Access to Justice Commission to know what initiatives the ADRC is involved in and vice versa. So I am not a voting commissioner, but I have the privilege of attending and hopefully serving as a resource both ways, because there's a lot of access to justice initiatives that the ADRC is involved in. So,
Okay, so let me get that one straight, Gail. Okay, so the Access to Justice Commission of the Supreme Court is
yes.
that?
Yes.
Okay, so you're the liaison from that commission to
Correct.
this commission. Okay, got it.
It's an informal position.
Are y'all still having those TIPS meetings in Puerto Rico?
Well, you'll have to ask Mr. Tarpley about that, since that was his year as chair, but that was a memorable TIPS conference. Yes.
That was when I was invited to speak. So if you all, care to do that again, I'm sure I could make myself available.
Now, the mid-year meeting of the ABA is in Louisville, Kentucky, and I know that's not very exotic, but perhaps you will see us there. So.
Wow. Dana and Noel, have you already met Justice Tarwater? Have you already met where you could be seen? Or is this the first time?
Justice Tarwater and I have spoken. Good morning, Justice Tarwater.
Hi,
We spoke
Dana.
last
Hi.
week. Yes, this is Dana. Yes, and so he has not had a chance to meet Noel.
Okay, Noel.
Morning, Justice Tarwater. It's nice to meet you.
Hi, Noel.
And I'm Dana's counterpart for all the mediators. So, we look forward to working with you and getting the job done.
These are the people you need to know.
Yeah,
They do the work.
The AOC staff, and they're providing all of that support that is essential to, keeping this commission on track and going forward. And so, well, Justice Tarwater, I've talked to you on the phone. As you know, my term ends as your term begins. And we're delighted to have you. Obviously, we had a great working relationship with Justice Lee. We look forward to, the commission looks forward to a great working relationship with you. As you know, Justice Lee, in addition to Rule 31, had us draft a Tennessee Supreme Court ADR plan. And so that's going to be on the agenda then in January to continue that plan in conjunction with the Rule 31 plan. And so there'll be some of the things you'll be talking about. And so delighted you're here. I will tell you, and I'll say this at the end of the meeting, you're getting ready to work with a wonderful group of people. And so I'm not sure about their sense of humor sometimes, but that's okay.
Yeah.
But they are a great group of people. And so welcome. I'm going to turn it over to you now and let the commissioners hear some things about you that Tarpley doesn't already know.
Well, I was married to Mark Harwell's second cousin. And so that's the connection there, that my late wife was Mary Flowers from Dothan, Alabama, and Montgomery for a time. And Mark's mother was the matron of honor in our wedding. So there's a fun fact for you. So I mean, you all kind of know who I am and where I came from. And one of the things that didn't get a lot of play in my confirmation was the fact that I am a certified mediator. I've been a certified mediator for more than 20 years. Now, since Betsy has most of the business in Knoxville, nobody ever asked me to, really mediate any cases much. But I am a mediator. I've done a few, not many. I will tell you that during my practice, a lot of my cases were mediated. And so I will bring a little different perspective, I think, to that. And many of them were mediated on a nationwide basis. So I've seen mediators from several different states. And what's that word again, Chuck?
You're muted, Chuck.
Part of our scenario that we did with the annual conference had to do with mediators indicating they were certified versus the word listed. And so,
I see.
So it's kind of ironic that you would use that word. That's all.
You will hear all about that, Justice Tarwater, as you get embedded in this group.
Right, I was the token mediator in that play, and there was one apparently angry attendee who thought I should be disqualified from Rule 31 listing because I had told the pro se plaintiff that I was Rule 31 certified, because I didn't think that the plaintiff would really truly understand what a Rule 31 listing meant.
It was somewhat of a mob mentality there.
So, okay, I feel very well disciplined, and I will comply. Here's the sad part. Right before I walked in here, I asked one of the retired trial judges, why is it that there's not a lot of CLE for the trial judges at the Tennessee Judicial Conference, which is where I'm at right now as we are speaking. And he explained to me the nomenclature, the terminology of certified versus listed. So I actually had a preview of this, but old habits are hard to break, I guess.
They are, aren't they?
So I will do my best, but I've been listed since 2001.
Good job, Justice. Good job.
But most of my experience has been as an advocate during mediation, not serving as a mediator. But I do have that listing, and so I'm one of you, and I will. I hope to bring some perspective to that, and I'm excited about doing this. Litigation's awfully expensive these days, and alternative methods of dispute resolution can help people, can help folks, and so I'm all about that. So thank you for the warm welcome into your midst. I will not interfere, but I will offer ideas and maybe some help on how we accomplish what we want to accomplish. So,
well, Justice Tarwater, thank you. We look forward to your participation. And again, you're going to find this to be a wonderful group of people that, in fact, actually do have a pretty good sense of humor. Okay. So,
okay. Well, good.
Welcome.
We ought to get along great then.
Yeah. I can tell, so, well, welcome. All right, Dana, then Justice Tarwater, with your permission we're going to go on through the agenda. And I believe we are now down to the statistics. Is that correct?
Yes.
I'll turn it over to you.
Okay, so we'll share screen. All right. So, Steve, these are the statistics for mediator reports from July 1, 2023 to September 30th, 2023.
Okay.
So, according to the report, there were 1,747 issues mediated, and of that, almost 66% were resolved through mediation.
Yeah.
Right. And
will you go to the one with the in-person versus video?
Mm-hmm.
Well, she's doing that. May I ask a question? I want to be clear. These statistics still do not include the CMC mediations. Is that right?
That's correct. I was going to jump in when this is done, just to make sure Dwight understands that there is another component of what's being done in the state.
So,
Sorry.
Yeah, and the fact is that there's two parts that the CMCs, and they're still under-reporting, and that's one of the things we talk about is reporting anytime we have a conference. And so what I found interesting is that I went back and compared this to last quarter, and of course the number of mediations are up, although it's just a slight change, is that I had seen a steady increase of in-person since the pandemic was over. And it has steadily increased every quarter. And so last quarter, then it was 63.4%. And now it's 61.7%, a very slight downtick. But this is the first time this year that we've actually seen where it's actually gone down a bit. And I'm always surprised. I thought after we actually got into Zoom, there might be more, but still the predominant number are in person. And so certainly, as Sarah Fiegel will tell you, that one, we believe there's underreporting. We hope to deal with that, the commission coming up this following year. And also, Sarah, if you'd like to share with the Justice then the perspective of the CMC.
Yeah, just very, very briefly. I can tell you collecting data has been a priority for the last 2 years. And this year, I got data from 5 of the 7 community mediation centers and can say that they collectively completed 976 mediations, most of which are not included in these numbers. Those mediations were done across 23 counties. So and the percentage of video mediations or video and remote mediation is far higher because, of course, what we're trying to do is ensure that, kind of like telehealth, that remote mediation could be made available for any of the counties for lower income litigants who otherwise would have no access to support services. The challenge in reporting, we don't even have to go into the weeds there, but we're tackling it. And it would be nice to think that in the next year, we could make some progress there.
Yeah, I'm sure you will, Sarah. Thanks, Sarah, for bringing us up to date on that. And so, okay, the calendar, then attachment 4, then Dana. I'm sorry, does anybody else have any comments about the statistics?
I'm just curious, how is I understand there's a higher percentage of video mediations conducted through the CMCs.
Mm-hmm.
But how does that Zoom number compare to the previous couple of years? Are we finding that people are going back to face-to-face?
No, what we're finding, and it depends on where you are. I mean, sometimes, like I think if you talk to Jackie Kittrell in Knoxville at the CMC, they're doing more in person locally, but NCRC, for instance, is now taking referrals from 17 counties, and it's only because of the move to remote mediation. And we're finding that really the remote option, when people are given options, particularly with parenting plans, maybe they have attorneys, maybe not, maybe a GAL, maybe not. For hourly wage workers or for people with childcare issues or transportation issues, it becomes an access issue. And in fact, offering the remote option makes even attending mediation far more accessible. We all have seen a dramatic drop in no-show rates, for example.
Yeah, interesting comment there. And so,
and they're doing
yeah,
it by smartphone, Dwight. I'll say, it's not that we know that people are not sitting at beautiful desktop computers. Often they're mediating from wherever they might be on a smartphone, and they're getting good agreements that hold up. So
that's going to be a deep dive this coming year then, Justice Tarwater. And so, okay, Dana, what about the quarterly meeting report? That's me. There you go.
Mm-hmm. All right, so these, in keeping with how the meetings have fallen in the previous years, this proposed calendar would be the same. So it would basically be the same the same Tuesday of the week at 10:30 Central Time for the next year. So these are the proposed quarterly meeting dates.
Yeah. So, okay, I don't think there's any question about that. And so let's go to the AOC staff report. I'm sorry, question?
No, can I just, I don't think this makes a difference. I will be actually out of the country that week in January.
Mm-hmm.
But these, I can still plug in remotely, I guess. So I don't think it needs to be changed on my account, but I just wanted to give you all a heads up about that.
Okay.
Okay. And the staff has been really good. It is recorded and there are minutes and that sort of thing. And so you could always catch up then, Justice Tarwater.
Okay,
so good about that. Okay. Dana, the AOC staff report.
Okay. So as of September 30th, we have 1,268 listed mediators. That's not counting, of course, what will be approved today. The other thing to remember is we have started renewal season. Annual renewal deadline is technically December 31st. The Rule 31 does give mediators an extended renewal period till March 30th. But that does come with an extra fee of $50. So we are in the midst of renewal. Also, medical debt, the online debt resolution pilot program is going well. During the summer, we had a vendor build a platform for a pre-suit mediation and hospital debtor communication. And so the first year we built it, we worked through it. And then this summer is when we had the bugs, we identified the issues with the platform, updates that we thought would help make it easier to navigate. Those were completed in the summer. And then beginning in August, our pilot hospital, which is Erlanger in Chattanooga, started releasing the what we call evites or invites. So there's a pool of debtors that meet a certain set of requirements to be in the pilot, and the hospital then emails them and texts them an invite to try to negotiate and settle their case, their outstanding debt with the hospital before it goes to collections. And so I have gotten the first set of data, and beginning August 18th, the hospital released 376 invites, and the 1st of October, out of that 376, 106 registered. That means they responded and were technically enrolled into the pilot. And of that, 46 cases were resolved. what was interesting for me is, and what we wanted to track was, of those 46, how many was resolved with a mediator and how many were resolved without. 24 were resolved without a mediator, but 22 were resolved with a mediator. So it's about 50-50. And the amount of debt resolved was $117,158. So Erlanger is happy about that. Erlanger has stated that this does produce more out of collections than sending it, of course, to a collection agency. So Erlanger has been really great to work with. They are very involved. We have a volunteer mediator pool. They have been great, Steve. They're very responsive. Um, the hospital is trying to limit the amount. We're releasing about 100 at a time in the beginning, but at the same time, the mediators, they were really starting to pick up on requests for mediation. The hospital can request a mediator, or the debtor can request a mediator. And on some, the hospital did decide that if there wasn't a response after registration, they were going ahead and requesting a mediator in hopes that it may jumpstart negotiations between the two. We also, our email, the AOC has an email that can be used by the invited debtors as well. And we do get emails after a release. Usually, is this real? Is this spam? What is this about? So it's great because then the AOC staff can also interject and say, absolutely, here's who you contact, and the hospital wants to work with you. So yes. Steve, do you have?
Yeah, well, let me make two comments, Justice Tarwater,
Mm-hmm.
about that. The first comment that Dana Schmidt pointed out was the renewal period is coming up. We give mediators until March 1st. You're getting ready to hear a proposal for us to submit something to the Supreme Court for a change in Rule 31. I'm going to come back to that. You're going to hear about that in just a moment. The other thing that that I'll tell you about the med debt is that we always did mediations in person. Then the pandemic hit and we moved to Zoom and to other online. Now with the med debt, what we're doing is, as mediators, is that we are now texting asynchronously. And that is very new for us mediators, those of us in that pool. And so you will hear a lot more about this. In addition, this medical debt ODR pilot program has gained national attention. And so it is something that is really critical for those of our fellows in our communities who in fact can avoid a judgment or bankruptcy. So this is a great program you're going to hear more about. So thank you, Dana. I think that was a great report. And so any other comments? Does anybody else want to make any comments about that?
I think it's the only program of its kind in the entire country. So
yes,
pretty forward thinking.
Mm-hmm.
Yeah. So you'll be hearing a lot more about that, Mrs. Tarwater.
Mm-hmm.
And so, okay, the committee reports then. Cindy, let's start with you.
All right, let me unmute myself there. We do have the newsletter, I believe. The materials for it are with Dana. We had a bit of delay. You can check and see. It's been mailed about a week ago, maybe.
Yes. So Cindy,
yes.
we are working with the newsletter. We want to have it published by end of fall. A couple of things we want to add: the new mediators that should be approved today, for the fall, and then we want to wrap up and add pictures from we need to. My goal is to add more visual to our newsletter. So we have the event where Justice Lee retired, and we also have the workshop event where we have more pictures. So we expect the fall newsletter to be out by the end of October with updates and nice pictures.
And it should be quite full this time.
Yes. Yes.
Yeah. Okay. Well, thank you, Cindy. And it's going to be coming out shortly. And I love the idea of the pictures. That's great.
Mm-hmm.
And so, Sarah, let's talk about your committee's work.
Holy moly, we've been busy. The only thing that I'll go on about at the moment is the fact that we did submit a request for an addition of a policy change that was unanimously approved. The purpose of this is, the ultimate goal is that because in Rule 31 and on the AOC website, we refer to Tennessee Community Mediation Centers, we do need to have some kind of a definition of what that is so that we know who counts in a way. We need a little bit of gatekeeping. So we have created a policy that conveys to people, to people who are starting new CMCs, for example, and wish to be included, some basic requirements. There will be an application process, and there's, we're looking forward to this really strengthening the community across the state and our capacity to collect unified data and so forth.
Yeah. Justice Tarwater, just a little bit more background information. What occurred is that when you look at Rule 31, there's only one part of it that refers to community mediation centers. It's Rule 31, Section 15A1. And that section refers then to community mediation centers as providing then CME credit, et cetera. And what occurred was we started just getting, we had before just applications from anyone. And the question is, well, what's the criteria? And so what this committee did was to come up with two parts to it. One, this is the policy, and we only needed a policy that went into our policies itself. And then there's also an application that somebody will have to fill out so that we can get the legitimacy of the organization who is applying for, quote, formal CMC status. Thank you, Sarah.
Yeah.
Okay, what's next?
I think I'm next.
Okay, yeah, Betsy.
The Rules and Policy Committee. We've been somewhat busy too. The ADRC chair has asked us to look at the policies and review them, see if any need to be updated and or modified. So the ones that we have been able to look at our meeting in September was policy number 16. And if you'll, policies are attached, I guess, as a link. Number 16 relates to inactive Rule 31 listed mediators. And we are recommending that this policy be deleted because Rule 31 no longer recognizes an inactive mediator. So this policy probably doesn't have any meaning anymore to the ADRC. And so we recommend that this be deleted. And I don't know, do you want me to, do we want to vote on?
Why don't you go through all three and maybe we can just do a collective motion?
Okay. All right. Well, then policy 19, it has several sub-factors, sub-paragraphs. And the third one has an asterisk after the DV designation in parentheticals. And this is just removing, our suggestion is just removing the asterisk because we really weren't sure what that asterisk referred to. So the recommendation is just to remove that asterisk, that notation. And then the third thing, of course, was what we were just discussing or hearing about was this new policy 20 regarding the definition of a CMC. And the Rule and Policy Committee met and recommended that this policy be approved in its entirety. And I think that'll be very helpful to us knowing how to get or how CMCs are defined and not having just random people out there providing community mediation that isn't actually listed within the ADRC rules. So I would
any discussion about these policies before we move to an amendment to the rule? Any discussion or a motion to approve those policy recommendations?
Motion to approve the policy recommendations.
Second.
Okay, all those in favor, if I could see your hand, it's easier on a voice vote. Okay. All right, very good. All right. Those policies have been, thank you, Betsy. Let's go on to the proposed rule to amend Rule 31.
Correct.
Justice Tarwater, we're going to be asking to amend Rule 31 here.
And Steve, if you want to champion this, you can. I can talk about it, but this really was something you came up with.
Yeah, and so, well, Dana, I'll actually turn it to Dana, and then I will make my comment about it. Dana, do you want to, because you were actually had the ones that were applying, or do you want me? You were dealing with them direct, those that were upset about this, okay?
Mhm.
So I'm gonna let you, then I'm gonna make my comment at the end.
So, I feel like this is a little bit of hot potato because really the champion of the meat of this petition is comes from it's Chuck. It's Chuck Hill.
That's
Um,
right.
and I brought the issue to it started with the credentials committee, which is chair is Lori Reed, and we have Chuck Hill, and we have Betsy Meadows, and we have Mark Harwell. And they're fabulous. They're always when we have these subcommittee meetings, they're so in depth, and we have the usual petition or applications, but what'll happen is you will have these other issues that arise that really there's not a true process identified in Rule 31 for them to follow, and it's kind of just put on their plate. And they're always intense in their discussion about what do we do, how do we handle this, and so this issue came up with in this particular section of the rule 15A 5, where it says if at the time you apply for your application, that is when we look at how long your training, your initial training to become listed, how long ago was that? Because if you lapse, Rule 31 says you can reapply because once you lapse, that's it. You have to start all over. You have to start a new application as if you never were listed. And Rule 31 says at the time you make that application, the committee has to look at your prior, that initial training is what I call it, that initial 46-hour training. And if at the date of that application, that training date, that completion date is more than 6 years old, you have to retake that initial training. So if we had a particular applicant who just in the midst of everything, he missed renewing, and he was way past 6 years, let's put it that way. His training was way more than 6 years old. And so when I let him know what the rule said and when it appeared on paper, it looked like he was going to have to take a 40-hour training again. It did not go over well. And this was a mediator who we tracked his reports, and he was mediating probably 1 to 2 mediations at minimum a week. And so the discussion came out of that from the credentials committee was, is this really fair? The rule didn't allow for much movement either way. And then there were a couple of other cases as well. So
Yeah.
at that point, Chuck was like, I think it's time for this committee and the commission to push to add some discretion. And so he,
Yeah, pull up the language right now there, Chuck, and we'll have Chuck turn to the language that he drafted that we're
so
recommending.
just to let you know, we included the background. I spoke with previous managers who were present and those who were around when the rule was drafted, this particular subsection. And so we have the background on that. And then Chuck was the one that proposed the change in the language. And so that is here.
If I remember,
And mhm.
if I remember correctly, we had about 3 cases in the last year and a half where the party who lapsed did so as a result of an error. They didn't get the email. They claimed that their secretary handled those things and they changed secretaries or they moved or it was something other than I decided not to pay my $150 this year and I'll do it next year. That wasn't the case. When I talked with John Jefferson, who had been the previous program manager, he said the reason that this rule had been put in was because they wanted to make mediation a more professional activity. They did not want people dropping in active and out of active status. depending on how they felt about paying the fee or what have you. And so it seemed to be a punitive approach to those who decided to lapse and not renew, and then decided later, well, I guess I'll renew again and try my hand in this mediation business. So since that was the intent, we thought, well, we've had a couple of cases where the lapse was due to an error. The staff was very good about tracing how many times they had sent out messages about renewing, and that people had adequate warning and so forth. But nevertheless, there was some type of an error. The case that Dana mentioned earlier, where the guy had mediated a couple of times each week, in addition to that, he taught mediation at Belmont and another university, I think Lipscomb or somewhere.
Nashville.
Nashville School of Law, you're correct. And so, it just seemed punitive to ask him to go back and retake this training. It just didn't make sense. And so I thought, well, maybe, one way to address this would be to give the commission some discrepancy when it came time to deciding when someone's training would need to be retaken again. That's the genesis for this.
Yeah. So Justice Tarwater, just to make sure you're clear of what we're getting ready to propose, is that Section 15A-5 basically says on March 1, if you haven't renewed and your training was previous to 6 years, you had to go back through the whole process, reapply, and go get your 40-hour training again and pay whatever it is. It was a hard stop. Okay. And so as a result, then, what we're proposing and what Chuck drafted and we have agreed with is that if you take a look at the language, let's go to the language, Dana. And this is for Justice Tarwater. Then
There.
a mediator whose credentials have lapsed for failure to comply must reapply for listing, must have taken all required training. If previous training was completed prior to 6 years from the reapplication for listing, it may, at the discretion of the ADRC, no longer be considered valid, and the applicant may be required to retake the training pursuant to Section 14. In other words, then, it's not mandatory. It's only if the commission at its discretion decides to say, wait a minute, we think this person does need to retake the training and to go through the whole process, but it gives the commission then the discretion as to whether or not, for example, the example that Chuck just gave you, we would decide that, in fact, I think the commission would decide that person does not need to go back through the retraining.
So to me, I agree with Chuck and the commission that this is, as applied, is probably too harsh. Now I'm hearing this for the first time.
Yes, we know.
But what strikes me is, how would the commission exercise its discretion? There are no guidelines that I know that's what I'm going to get asked. So when do you exercise your discretion and when do you not? And it's like if you could add a sentence that among the factors to be considered are the reason for the lapse, the time period during which the listing was ineffective or the listing had lapsed. I don't know whether you want to say something like personal issues involving the mediator, or health reasons, or, it seems like you could, otherwise, you could be in a situation where you are attempting to exercise your discretion without guidelines to really do that. So that's how it strikes me. Now, maybe that's the way you want it. Maybe maybe you want to just take them on a case by case basis and say, like, this person will bring, they don't have to take it. I never liked that one. He or she get any cases settled, and so let's make them go back and take all 40 hours. So
Yeah.
so so anyway,
It's good. If I could, go ahead.
Go
I'm
ahead
sorry,
and
I
finish,
didn't mean to interrupt.
Betsy, go ahead before I make my comments.
Well, I agree that some guidelines would be helpful. But being on the credentials committee, when these things come up, I mean, one of the reasons, if I recall correctly, the longtime lawyer, his assistant had been with him for maybe 35 or 40 years, and she died suddenly. And that was one of the reasons, and he was trying to figure out how to manage his practice, and two or three others had to do with their email changing and the email not coming to them because it fell into their spam or it didn't get forwarded. And so it's going to be hard to put down guidelines that will be definitive. I think, at least I think we discussed this, that we're going to be sort of flapping in the breeze for a while to determine whether we need guidelines or whether it can be on a case-by-case basis.
If I can add something, I don't know that I would call it a guideline, but it certainly would be a consideration. And that is that the retraining would have some effect. I mean, in the case of the guy who's been teaching mediation at 2 different graduate programs, retraining wasn't going to do a thing for him. And so I think one of our considerations would be that the retraining will in fact help this individual become a better mediator. If that's not the case, then that would be one of the considerations. I don't know what I'd call the guideline.
Yeah, well, let's marry those two things, Justice Tarwater. Let's marry what Betsy said and Chuck just said. One, the 2 guidelines that I remember emerging was, why did they miss the deadline? Okay. Here's somebody that did it for 10 years, nothing's happened, and he just negligent, or is there some good reason for missing the deadline? That's Betsy's comment, is that then let's then marry with that Chuck's comment, and that is, wait a minute, do you think it's necessary for this person to retake the retraining because of the fact that there's been no mediations being conducted, he's not attended any CMEs, et cetera? We'll look at the CMEs, we'll look at the CLEs, we'll take a look at the number of mediations that the person is taking. And so we've had some discussion about those matters. And so here would be, and so I marry those 2 concepts, okay, that we just talked about. Here would be my suggestion, is that, Justice Tarwater, would it be okay with you if the commission then drafted a policy, okay, that reflected what those guidelines are that they should consider? Because there's going to be some open texture to that and a need to apply. Could we then hold off until the January meeting to submit this, and at the time you can see the policies that would be the guidelines?
I think that would help me with the court. And, based upon my tenure there, I'm looking for all the help I can get. I am, an objective, and this gets back to what Chuck was saying too. An objective criteria is how long the person has been out. That's pretty objective, right? If you've got a person who let his or her listing lapse for 20 years and then wants to come back, there's every reason in the world, it seems, to make that person through the initial required training. But that gets exactly to what Chuck was saying, I think, about would it help? And so I do lean on the rules not being overly wordy, verbose, complicated, and that kind of thing. So I really like the idea of having a policy that would reflect some of the factors that would be considered in dealing with these specific kinds of cases.
Okay.
And maybe that to me sounds like a good way to do it.
Yeah. Mark, did you have a comment?
Yeah, I completely agree with Dwight in this regard. And being a part of that process, I understand exactly why we are where we are. It just occurs to me that we need to have a little bit of discretion and not have be crushed with a litany of reasons. And it occurred to me that maybe the Rule 60 relief from judgment might be something that we could think about borrowing. And I think if you're showing up excusable neglect or mistake, might be what we need, because if somebody has sat around for 20 years or 15 years, that's not excusable neglect or mistake. If somebody missed it by 6 months or what, it's, when you see it, gives us a little bit of a definition that makes me more comfortable, because I've always been a bit concerned about the slippery slope and how we can justify what we're doing. So I do like having a bit of teeth in it.
Yeah. So, well, let me make this suggestion to the commission, and you tell me what you want to do. I would suggest that we move this discussion until January 16th before we vote to move it to petition the court. Hold off until the 16th. And I know, Justice Tarwater, you're going to be out of the country, and so it may get kicked down the road a little bit more. But that I would suggest the following. One, that the committee get together and come up with some guidelines. They may not, there's some way to embed some objective factor, but to come up with the guidelines. Then once those guidelines are drafted, get them to Justice Tarwater then well before the January 16th meeting, if possible. And then at the January 16th meeting, then Justice Tarwater, you can have then the request for the change to petition the court for a change in the language, along with the guidelines and an explanation of those guidelines, but more importantly, to get them to you well before that meeting, so that you may very well have a chance also to make some comments. And actually, I would invite possibly that you attend the committee meeting. And so that might be a good idea. And Justice Lee has attended those meetings in the past on occasion. And so, Dana, I would suggest that the committee consider then inviting Justice Tarwater to that meeting. Commissioners, does that work for you?
Steve, I have one question.
Yes.
The question is to Dana and Noel, who had some concerns about whether this would open the floodgates to just an incredible number of requests. Does having guidelines like this make you a little more comfortable, Dana and Noel?
Absolutely.
Okay.
Yeah.
Okay.
Absolutely.
Because it helps us refer the people to those guidelines or the policies so they can see if they qualify.
Okay.
This doesn't happen all that often, but when it does, it takes a lot of time, because Dana and Noel do, an inordinate amount of work prior to getting it to the credentials committee. And then we have to look at it and spend quite a bit of time discussing and determining why, how, what. So I don't know what my point was, other than I do think a little bit of guidance could be helpful, but I don't think it's going to really change the amount of time that we devote to decide whether these people should have to go through the training again.
I think, Justice Tarwater, there's one thing that we're all in agreement with here, I believe, is that the way it's written now and with the way it's developed now, that we have very few individuals like that the rule is simply too harsh, and we want to simply to lighten up on the rule to give some discretion, but I think guidelines are the way to do it.
Okay.
Yes, and Chair,
I'm going to suggest that there's no motion made to petition the court at this point, and simply to wait until the 16th and have the committee meet before the 16th and have a discussion with Justice Tarwater because of his long tenure on the court, right, Justice Tarwater?
Sounds like a plan.
Okay. All right. I don't think there's any need for a motion. If there's no motion, then we're going to kick it down the road to the 16th. Okay, Ethics Advisory Committee. I'm sorry, the Grievance Committee.
Yes. This should not be shown. We received a grievance earlier in last year in relation to Rule 31. Grievance submitted a complaint related to a mediation. The complaint was lacking in information in order for me to ascertain whether or not it was ready to move forward on the next step, which is to send it to the chair, who then will appoint a grievance committee. And so, as normal practice, I replied back to the grievant and asked for some more specific information. And we just didn't get that information. Did not get that information. And so what happened was in speaking with the chair, it was decided that what we had as far as information and facts would just be submitted to the committee. The committee reviewed it and then made a decision. And and then based on that decision, the letter was drafted and then sent to the complainant.
Yeah. The critical thing that we're saying here, Justice Tarwater, is that the complaint form, by the way, says provide us with detailed information about what your complaint is. And basically, as I recall, it was talk to my attorney. Well, no, that's not our job. You got to supply us with the information. Okay. Advisory opinion, Rick Ladd.
Sure. Steve, if you would give me just a minute before I give my report, if that's okay with the chair, just to express some sentiments I have about the ADRC in light of my departure. Would that be okay?
Yes, I was going to give you that opportunity at the end, but I'm delighted for you to take it now.
Well, I think that you're the appropriate person to end the meeting with that. So let me just tell you what my experience has been. Many years ago, I was appointed to this commission by the Supreme Court as a civil litigator who occasionally mediated cases, participated in a lot of mediations as an advocate, as Justice Tarwater mentioned his experience. But I feel like that I'm leaving more as a mediator who litigates, and my mindset change has been as a result of working with all of you. I started this entire process with a very, very narrow worldview of mediation. And by working with you, that vision has been greatly enlarged, and it certainly has increased greatly my understanding of ADR as an invaluable tool, and I think it is a tool, to resolve disputes in virtually all civil litigation, civil dispute would be a better term, settings. And I know you're not used to me being serious, but I'm going to continue being serious. I have greatly enjoyed working with all of you. I really think that discussions with many of you have increased my worldview just in general, not just in the area of ADR. You are an extremely talented group who obviously take your work on the ADRC seriously, and you do so with unmatched zeal and enthusiasm. So I thank you, and Justice Tarwater, I thank the court for the opportunity to serve. And being a Navy veteran, I wish you all fair winds and following seas. Thank you.
Thank you, Rick. Thank you for your service.
Thanks,
We
Rick.
really appreciated it. Yes. And I'll be making some comments at the end too.
All right. On the Ethics Advisory Committee, and again, if you'll look at tab 9, that was the one advisory opinion that was issued. And Mark, Betsy, or Lori, if at any time you'd like to jump in, since you're responsible for this and I'm simply the mouthpiece, but the issue had to do with whether or not Tennessee recognized what I've heard called in training and the like as MEDARB, or mediation arbitration. And the question was whether or not a mediator could subsequently act as an arbitrator and resolve the dispute that he or she had previously mediated. And under the wording of our rule as currently written, that would be prohibited. And the reason it would be prohibited is because the rule specifically says that during and following a Rule 31 mediation, the mediator shall refrain from participation. It says as a judge, and you can look at that as official or unofficial, but it also says quasi-judicial capacity. In other words, you're making a determination of the issues instead of trying to bring the parties together for a mutually agreed upon resolution. So that was the one advisory opinion that was issued. Again, Mark, Betsy, or Lori, do you have any other comments on that one?
Yeah, does the committee have any other comments? What about question number 2? Mark, you want to take that too?
Yeah, I think question 2 it rests on our response to question 1. So I think it's pretty clear cut once you cut to the chase and see the conjunctive between during and following, and then the command shall.
And my expectation is we have not seen the last of this issue. I know that I have both been the requestor and the requestee to do exactly this. You're in the tough mediation as a litigator. You don't seem to be able to reach a decision, but both sides have perhaps intimate familiarity with the mediator, trust his or her abilities, experience, and skill. And, you know, why don't you just go ahead and resolve this instead of us spending another $100,000 getting ready for a trial on the merits? And I would say maybe 10% of the time in my mediations, the idea is floated about. So it could be that again, this comes full circle, and the issue is raised again, perhaps with a request that the rule be altered. So I just bring that to your attention. And then Dana, correct me if I'm wrong, the second opinion that has been, or the second request that has been made, that's still in the preliminary decision process. And I think one of the determinations we discussed was whether or not it was truly a request for an ethics opinion. Is that correct?
Yes, you're correct.
And so, Mr. Chairman, that is my report.
Okay, let me make a couple of comments. Thank you, Rick.
You're welcome.
And thank you for your service on the commission. I have thoroughly enjoyed our interactions and your intelligent comments and your wit. And it will be missed by me, even though I'm not on the commission. I know it will be missed by others. So thank you very much. So yeah, the committee met on this, and I think that this has come up a number of times, and I realize that there may be differences of opinion about what should or should not be done, but our rule's clear. And the other question that came up to me at one point was, well, can the parties waive it? And it's pretty clear to me that there's an absolute prohibition. The mediator has to refrain. And so under question number 2, are there any circumstances that would permit the mediator to do it? For example, by waiving the provision, the answer is no. And who knows in the future what the crystal ball is going to say about any proposed amendments and that sort of thing. But that's the rule right now. And section 9D4 of our Rule 31 provides that this is the opinion of the advisory committee. It doesn't need to go any further among the commission members. We, as a matter of practice, have simply submitted before it's been published to the commission to see if anybody says, hey, I think you guys are this committee just absolutely wrong. And so unless someone thinks that this committee has simply way off base in terms of the way it's interpreted, then pursuant to Rule Section 9D4, then it will be published on the website. Is that correct, Dana?
Yes,
Okay.
that's correct.
Okay, not hearing anything then. Dana, let's move on.
All right. We are ready for training in the Education Committee.
Okay, I'm filling in for Marcus Rudolph, who was not able to be here, who is the chair of that committee. We had 3 applicants requesting training waiver requests, and I'll ask Dana to put up the worksheet for applicant ending in 2630. What we do is we have a process where we look at the training that the individual has had and compare that to the requirements under Rule 31. And if you'll show us a little more of that, where you can see the actual check marks, staff has gone through and determined that most, if not all, of the areas that we require under Rule 31 have been satisfied by the training. There are a couple, for example, whether or not the person has been trained in Rule 31. Obviously, if they're from some different state, they're not going to have that type of training. And sometimes we have a cultural issue, but in general, for the most part, we consider that this training has in fact been equivalent to what we require. And the committee voted to approve this person as having met the training requirements. So are there any questions on this particular applicant? Hearing none, can we have a motion to approve this training waiver for applicant ending in 2630?
Motion to approve.
Second.
It's been moved and seconded to approve this one. So take a vote. Those showing approval, please raise your hand or say aye. All right, motion is approved. Moving to the next applicant, which is ID ending in 3710. And if you could show the worksheet for that one, Dana. A similar situation in that the applicant satisfied all of the requirements with the exception of the ones that you would not expect them to be able to satisfy because they're out of the area. This person was trained in Hawaii, but met all of the other requirements, and we believe their training has been equivalent. The committee voted to approve them. And so are there any questions regarding this applicant? Hearing none, I'll ask, is there a motion to approve?
So moved.
Second.
Moved and seconded to approve. And all in favor, raise your hand and say aye.
Aye.
Motion is approved. Thank you. And the final committee member, or I'm sorry, the final application ends in 2684. Let me see if I got that right. No, I'm sorry. It ends in.
It should be 709, Chuck.
Yes, thank you. Similar, if you could put up the worksheet. I really like these worksheets because it kind of zeroes in exactly on what type of, if you can scroll up till we can see those check boxes. It really zeroes in on whether or not the important elements of training have been satisfied. And again, in this case, the person satisfied those. I happen to know the guy that runs the program in Hawaii, and they do a pretty thorough job, even though they're much newer than many of the other ADRC programs. Any questions regarding this applicant? Okay. Can we have a motion to approve 6370?
So
Motion
moved
to approve 6370.
Second.
It's been moved and seconded. And a vote to approve. Everyone who agrees, please raise your hand or say aye.
Aye.
Thank you. It's approved. And I don't have any other elements to report for the Training Commission.
Thank you, Chuck Hill. Appreciate it. And Credentials Committee, Lori Reed. Hey, Lori, is your voice going to hold up?
I'll try. So we had a lot of applicants, and I'll start with the civil listing applicants, number 163697 through 162664. We have would like to approve, and I'd like to see if there's a motion for those applicants.
So moved.
Second.
All those in favor of 163697 through 167664 on the attached sheet, please raise your hand. Is anyone opposed? Thank you. That would, those are approved. The family law applicants on the spreadsheet that was attached to your agenda, number 163713 through 162669, we are recommending approval. Is there a motion?
So moved.
Second.
All those in favor, raise your hand or say aye, please.
Aye.
Anyone opposed? Thank you. The next applicants are the ones that had training requests, and we just approved those training waivers. And our committee is recommending approval of 163668 and 162664 as long as they passed the training waivers, that we would approve them for their, let's see, the first one. I think they're both family. I can't tell on that. Yeah. So is there a motion to approve 163? Let's see, for the training. I'm sorry.
I move that we approve the 3 training waiver applicants.
Thank you. Thank you.
I'll second
And
it.
is there a second? And all those in favor, raise your hand, please. Is anyone opposed? Okay. We have 4 applications that had disciplinary issues. 163710. Oh, excuse me. I'm sorry, y'all.
We can't hear you, Lori.
I'm sorry. I'm looking for the ones that my glasses aren't working.
Are these the disciplinary ones?
Yes, on the disciplinary ones, 162672 had a BPR that was on diversion in 2008, and we reviewed the documents and we're recommending approval. All those in favor of approving 162672?
Okay.
Is there a motion to approve that one?
Motion to approve.
Second.
Thank you. Thank you. All those in favor of approving 162672, say aye or raise your hand. Is anyone opposed? The next disciplinary issue was 162666. They applied for family and they had a private admonition in 2020. The committee is recommending approval. Is there a motion?
So moved.
Second.
All those in favor of approving 162666, say aye or raise your hand. All those opposed, say aye. Thank you. Number 162684 is applying for civil. There was a private informal admonition in 1986, a private informal admonition in 84, a private reprimand in 92, another private reprimand in 95. After looking at all these and seeing the length of time that is expired, the committee is recommending approval for 162684. Is there a motion?
So moved.
Second.
All those in favor of approving 162671, say aye or raise your hand, please. Anyone opposed? Thank you. The last one on the BPR list is 162671, requesting civil listing. There was a private reprimand in 2004, a private reprimand in 2010, and there is currently an open complaint pending, and the committee is recommending deferral until the BPR completes their investigation. Is there a motion for deferral?
So
Motion
moved.
to defer. Second.
All those in favor of deferring 162671, raise your hand or say aye. Is anyone opposed? And I feel like I may have missed some. Dana, did I miss some above there? Did you get them all?
Just for the record, if we could cover, you have applicant 163688, who was dual applicant, and applicant 162664 was a dual applicant. Both met all criteria and had no issues. They were on a separate tab, Lori, but just to make sure for the record.
Yes. Okay. So is there a motion to approve the dual listing applicants 163668 and 162664?
So
So
moved.
moved. Second.
Thank you. All those in favor of approving those two, the 163668 and 162664, raise your hand or say aye. Thank
Aye.
you. If you're opposed, say nay. Thank you. I think that covers all of the
Yes.
credentials committee issues.
I don't want
And
to
I-
belabor this meeting too much longer, but I want you all to know, especially Justice Tarwater, that we run through these really fast in this meeting, but we go through each of these. Well, I take that back. The ones that we approved that didn't have any problems, Dana and Noel have vetted them completely, and we follow what their recommendation is because they don't have any issues. But the rest of these, we go through one by one and look at each of their individual disciplinary histories and determine, what is the issue and the training issues and all that. So I just want Justice to understand that this is not something we, just run through and approve everybody.
Mhm.
Good point,
Thank
Betsy.
you, Betsy. That's correct.
Of eyeballs on these. So.
Absolutely.
That's correct. We don't accept just anybody.
Well, I will echo Justice Tarwater. What Betsy Meadows had to say is that I attend those committee meetings, and I can assure you they are taken apart very carefully, and the committee takes it very seriously. So that's why it makes the commission to have a much easier job, because of the committees on this commission work extraordinarily hard before we ever get to the commission meeting. This meeting is simply the tip of the iceberg. All of the hard work is done in those committee meetings. And so that's what you're hearing Betsy Meadows say to you. Okay, Dana, anything else?
No, Steve, just based on the business from today, our next deadline for applications is December 7th of this year. And our next quarterly meeting will be January the 16th, 2024 at 10:30 Central Time.
Okay, and so I make a few closing remarks, although I joked with everybody at the beginning. The Jeopardy question is, which two commissioners roll off? And so it's Rick Ladd and Steve Shields. We had a Jeopardy show put on by Chuck Hill, Justice Tarwater, and so that's the reason for that. And so, I got to thinking about this, and I thought, if I wrote my farewell, not my will, okay? If I wrote my farewell, what would I write? And so I would write, did I get what I wanted out of this experience? I did. Well, what is it that I wanted out of this experience? Well, what I wanted out of this experience was to understand Rule 31 better. I wanted to understand the programs that was administered by the ADRC. I wanted to know how we could improve those programs, how we could support then the community mediation centers, and also how we could then ultimately improve then access to justice. And so I got all of those, but there was something else here, is that what surprised me the most was this, is that although that was a gift, working with all of you and your kindness and your intelligence and your wit and your collegiality was just overwhelming for me. And so what I'm taking away from this is a true gift that I will always remember. You, everyone here has just been great. And Justice Tarwater, I can't wait for you to get embedded into this group. I'm glad you know so many to begin with. And so all of you, before there's a motion to adjourn, thank you. You are a true gift to me, and I will always remember you. Motion to adjourn.
Well, I think
We don't want you to go. Looking to suspend adjournment for another few years.
I see. All right. Hey, everyone. Thank you. I can't tell you how much I care for each one of you and what a true gift you have been. And I never expected this sort of gift to be handed. I'm sure Rick Ladd has already told you exactly the same thing. What a wonderful group to work with. Thanks so much, everybody.
Thank you.
I'll be seeing you.
Thank you, Steve.
Now, stay safe, everybody.
Thank you.
Bye.
Bye.